Hello everyone and welcome to today's webinar. We've got a great presentation lined up for you today, but before we get started, there are just a few general admin points to cover. First and foremost, please use the online question tool to post any questions that you have and we will share them with our speakers. Second, if you experience any technical difficulties today, please let us know using that same questions tool and a member of our admin team will be on hand to support you. And finally, just to note, this session is being recorded and we'll be sharing a copy of that recording with you via email in the coming days. So, without further ado, I would like to hand over to our speakers to get us started.
Good morning, everyone. I'm David Bond. I'm the head of the International Trade Group at White & Case. Over the last year or so, we've seen a huge increase in client interest on forced labor risks and compliance. The interest has been widespread and it's included parties that are obviously interested, like importers and foreign producers that export goods to key markets. But it's become broader in the sense that parties that you might not typically expect would be interested or paying attention, including financial institutions and large project developers. Forced labor regimes are in effect or entering into effect in many key markets. And these regimes operate in very different ways and create different risks and compliance challenges. So our goal today is to bring you up to speed on these regimes in the US, the European Union, and the UK, and to talk about compliance strategies. We have Jessica Lynd in our DC office to talk about the United States, Sara Nordin in our Brussels office to talk to you about the European Union, and Chris Thomas in our London office to speak with you about the United Kingdom. We're going to start off the discussion with a few poll questions that Lucy's going to run for us. Then each of our panelists will give you a 10-12 minute presentation on their respective regimes. And then we're going to have a Q&A session based on the various questions that we've received from you at the time of registration. And if there's some time left, we'll also take live questions from the chat box. Lucy, could you run the poll for us, please? Okay, well, thank you for that input. That'll be useful, I think, when we get to the Q&A session. Jess, could you please lead us off?
Sure. Greetings from Washington, everyone. Again, I'm Jess Lynd, and I'll start by addressing the U.S. measures and specifically the Uyghur Forced Labor Prevention Act. First, it's important to know that before UFLPA, as we call it, the U.S. has long had a prohibition on imports of goods made with forced labor under Section 307 of the Trade Act. And how this works is through a process of CBP investigating allegations of forced labor, and then based on some evidence, it then issues either a withhold release order, which would detain the goods when there's reasonable suspicion, or a finding to seize the goods if there is probable cause. Then the importer can address the evidence against it and try to prove the goods were not made with forced labor. So importantly, two things under 307. First, there was some evidence of forced labor identified by U.S. Customs and Border Protection, CBP. And secondly, the measure is usually narrow. It can be a company, good, or country specific. For example, in November of last year, CBP issued a withhold release order on raw sugar and sugar-based products produced in the Dominican Republic by a specific company, the Central Romana Corporation. So Section 307 was on the books, and this framework existed for almost 90 years before the U.S. Congress ever started looking into the situation in China. And that brings us to the end of 2021, when the U.S. Congress passed UFLPA, and it started going into effect last year. This law builds off of Section 307 and creates a presumption that 307 applies to imports if any part of the good is produced or mined in the Xinjiang Uyghur Autonomous Region of China or by an entity that CBP has identified and placed on the UFLPA list. So what's different here? First, there's no CBP investigation with reasonable suspicion or probable cause. The goods are just presumed to be made with forced labor and presumed prohibited from import if they come from Xinjiang or an entity on the list. Second, in a way, UFLPA uses a different country of origin analysis than U.S. Customs typically uses, and it has no de minimis exception. So UFLPA is triggered if any input into the good, no matter how small it is, and no matter whether it was further manufactured or substantially transformed in a third country, if any input is from the region or an entity, then it's triggered. And you'll see on the next slide that CBP is detaining goods under UFLPA that have countries of origin besides China. And then interestingly, there's no consumptive demand exception. So until 2015, Section 307 had this exception where the prohibition did not apply if there was insufficient U.S. production of the good to meet demand. That was repealed in 2015, and it doesn't exist under the UFLPA law. So how does the process really work, and what can importers do if their goods are detained or seized? There are two ways out, or I should say through. You can claim the goods are out of scope, or you can try to rebut the presumption. So the importer can seek to prove that its goods are out of scope and not subject to the rebuttable presumption, meaning they are not from the region or any of the entities, by requesting an applicability review and showing its supply chain documents all the way down to the raw materials, including the parties involved, payment documentation such as invoices, movement documentation such as bills of lading, and other supply chain records that demonstrate there's no nexus to the region or named entities. And then the second way is to take on the presumption and request an exception by proving with clear and convincing evidence that the goods were not produced with forced labor. This is a high burden. And I'll refer you to the June 13th, 2022 operational guidance for importers that CBP put out. And it's worth spending a moment here to give you an idea of the level of detail that CBP is looking for. I think they break it out into 4 or 5 categories, but in my mind, it really breaks down into 2 types of information that CBP can require. And importantly, they can ask for it for your whole supply chain, no matter where the goods are from, but they're definitely going to ask for it for these specific goods that you're trying to import. So the first type is your due diligence system or program information, such as supplier code of conduct documents, trainings that you provide on forbidding forced labor, other supply chain management measures, such as the internal controls you have to mitigate and remediate the risk of forced labor. So That's the first chunk, we should say, the due diligence system. The second is the really detailed information about your supply chain map and records, which can apply, again, to your supply chain overall, but certainly for these specific goods. So first would be your map. That would be your list of suppliers and all of your service providers. Sometimes we accompany that with an affidavit from them. Second would be your purchase and payment documents, such as invoices and bank records. Then your movement documents, like bills of lading, manifests, inventory records, certificates of origin, import and export records. Then production. Do you have mining records? Do you have other factory production and capacity records? Do you have documents of factory visits? Or documentation of factory visits. And all of these have to be traced specifically to the accounting entries, and then that needs to roll up into the audited financial statements. Then we have the third-party audits for forced labor. These can show your due diligence system is in place and generally will check for the International Labor Organization's indicators of forced labor. And then finally, and probably most difficult, is worker information on wage payment and production output per worker and information on worker recruitment. And again, this is not just for your company, the importers' factories abroad. This is for the entire supply chain. And that's the level of detail you need when we say map or trace your supply chain to overcome this presumption. So interestingly, UFLPA also requires U.S. Customs to report to the U.S. Congress and to the public within 30 days of granting an exception. And it needs to report what the good was that they let through and what the evidence presented was. And to date, we haven't seen any of these congressional reports on the exceptions granted. And then for those of you who in our poll were showing that you work for an importer, if you know that your company is a member of CTPAT, either CTPAT security or trade compliance, then you should also be aware that in January of this year, CTPAT members have to have a documented social compliance program in place that shows how the company ensures imported goods were not produced with prohibited forms of labor. And this is not Xinjiang specific. This is for your entire supply chain. And if you're a member of CTPAT trade compliance, you have even more obligations, such as providing training on your program and implementing other controls. And there are a few benefits for CTPAT members, such as prioritized review if your goods are detained, and a few others. So Lucy, can we go to the next slide, please? So what's happened so far? This month, Customs and Border Protection published statistics on the over 3,000 shipments it's already detained under UFLPA. Interestingly, UFLPA and what was created called the Forced Labor Enforcement Task Force that kind of oversees it had named certain high priority sectors, which included tomatoes, cotton, and polysilica-based products. And they might be adding aluminum. In fact, just yesterday, Senator Wyden was issuing supply chain questions to automakers like Tesla in the United States, making sure that their supply chains didn't source from the Uyghur region. But the statistics here show on the right side that the enforcement is much broader. It includes things from pharmaceuticals, manufacturing materials, textiles, electronics, and base metals. And then the stats on the left show what I mentioned on country of origin, that the country of origin isn't necessarily China. In fact, the majority was Malaysia and Vietnam. So we don't know for sure, but I don't think it's that there's some sort of fraud. I think that the good really is manufactured in Malaysia in these cases, but it's sourcing some product from China, and that's triggering UFLPA, or it's sourcing something from Xinjiang. So a few takeaways and some examples of what we've been seeing. First, what's unique about UFLPA is that the U.S. is regulating through trade as opposed to business location, whereas some of the other measures we're seeing in Europe are locating based on where the business is registered, or are regulating based on where the business is registered. And then also the U.S. is choosing right now to focus on forced labor as opposed to other ESG issues. You'll hear from my colleagues that the UK seems to be going down this route as well, but we're starting to see the EU and other countries like Germany move towards much broader ESG due diligence. So far, the US has been targeted. And then, of course, the big question for UFLPA is whether this presumption is really rebuttable. As I mentioned, CBP has not reported yet on any exceptions granted. And we're seeing instances where Chinese producers aren't able or willing to provide the required documentation. There was a New York Times article this weekend reporting that Chinese nationals that worked for a US due diligence firm were detained. And I don't think they were investigating forced labor. It didn't say that. I think it was fraud or corruption. But the question is out there that can these companies really provide the information needed to overcome the presumption? And then it's also important to note that it can take time to move a supply chain and requalify suppliers. We've seen instances where companies have started that process, and until it's complete, the US is simply going without the goods, sometimes with no alternative supply or domestic production. And, is that really what the US Congress intended? So those are some of the examples of things that we've seen, and I'll leave it at that for now, but I'm happy to answer any questions.
Thanks, Jess. Sara, over to you.
Hi, thanks, David. So I'm Sara Nordin, based in Brussels, and I'm going to give a high-level overview of some initiatives that we're seeing on the EU side, and which are very interesting to contrast to what Jess just explained with the customs focus that we have in the US. The EU has been talking about forced labor initiatives for a long time and issued related guidance, statements, and so on. And the key initiatives that we see now is first the EU proposal for a ban on products made with forced labor. And then there's also a proposal for a directive which would impose due diligence obligations on larger companies. So we'll talk about those for the next few minutes. So looking first at the EU proposal for a ban on products made with forced labor, it's very different from what Jess just described. There is an angle looking at border controls, but it's only one small component of what the EU is proposing to do. First of all, the ban that the EU is proposing to impose is a ban on any product made with forced labor. So the focus is not just on imports of those products. There is recognition that there could be forced labor products made within the EU as well. So the ban would be on any placing of these products on the market, any making available of those products on the EU market, and also exporting those products out of the EU. So how is this going to be achieved? And bearing in mind that this is a proposal and things can still change, but there are some interesting features that the EU is proposing to put in place in order to achieve that. So what will happen is that there will be a market surveillance authority, essentially appointed by each member state, because in usual EU fashion, the regulation will be imposed at EU level, but it will then be for the member states to implement and enforce the regulation. What the national authorities will do is to essentially conduct a two-step investigation to figure out if forced labor is used in supply chains. When we look at the definitions of the different concepts within this regulation, they're quite broad in that, as opposed to what Jess just explained, it can apply to any third country, any product, any sector. But how these investigations, how it's envisioned that they will be conducted, there will be some narrowing of the scope in that the investigators are essentially receiving instructions to focus on the part of the supply chain that is closest to the risk of forced labor. So that would potentially at least limit to some extent the parts of the supply chain that the investigator would look at. The EU also envisions setting up a database where expert views will be submitted, and that will flag when there are particular products that would be of high risk. It'll be interesting to see how that would be implemented in practice, but that's what will be taken into account in order to identify high-risk products which are not defined in the regulation. So this two-step investigation will first focus on a preliminary investigation where the regulator will see if there's any substantial concern that there are products made from forced labor in the supply chain. It will look at the database that I just mentioned. It will look at potentially public reports of forced labor indications and a variety of information, and asking the companies themselves to show whether there is a risk or not. And what will be taken into account in this investigation is whether due diligence has been performed. So the regulation sets out certain principles in terms of what companies would be expected to look at as part of their diligence. The diligence principles are quite broad, however, focusing very much on international principles, the OECD and so on, which is a tendency in EU regulations to look at those international diligence principles. So that will be taken into account as an investigation is conducted. If there is a substantial concern, we move to the second phase of the investigation. And that is where the regulator will look at whether there is a cause, and the regulator has the burden of proof based on the information available to it, including any information that they could gather in third countries. And on that basis, a decision is potentially issued that will declare that these types of products in this type of supply chain, that they are made of forced labor, and as a result, they are prohibited from any placing on the EU market. That is when potentially the customs authorities come in. And this is what's interesting to see from a trade perspective, in that is when actually goods might be blocked at the border, and there will be customs enforcement. Again, looking at the enforcement of these measures, it will be very much left to the member states in terms of what penalties that will potentially be imposed on companies, and so on. So it will be very interesting to see how this will play out. The timeline is also interesting because this is at the proposal level at this stage. The Commission has issued this proposal. It's now being considered by the other EU institutions. Our estimate is that it is unlikely that this will enter into force before 2025, especially as the proposal has a 2-year transition period before the requirements actually start entering into force. So this is in the long term with respect to what's going to happen with this. So going to the next slide, just looking at the Corporate Sustainability Due Diligence Directive, which plays into the due diligence. I just mentioned that in the forced labor proposal, due diligence will be taken into account in an investigation. Any diligence that will be conducted under this proposal will be taken into account as part of that. What's important to note with respect to this EU proposal is that it's proposed as a directive, which under EU rules and regulations is quite different. It will not apply directly to companies. Instead, member states will have to implement the law into national law, which means that there is a higher risk of divergence between the various member states in exactly what the obligations are that are being imposed on companies. There is a recognition that there are various national initiatives that have already been put in place. For example, we're looking at France and Germany as having imposed certain due diligence obligations on larger companies, for example. So this is an attempt to harmonize, but the question is to what extent will actually these rules be harmonized in light of the fact that the proposal is in the form of a directive. So what does the directive say as it's currently drafted, bearing in mind that things can change? It does impose an obligation on larger companies that are defined by the turnover and the number of employees. And there are 2 categories of companies that will be potentially subject to these due diligence obligations. The focus will be on human rights, but also on environmental obligations. So it's an interesting combination of both a forced labor focus and environmental diligence. Companies will be expected to issue annual reports, so to refresh the diligence. And when an issue is detected in the supply chain, then companies would be expected to actually act on that and to mitigate whatever risk is identified. Again, member states will be very much in charge of issuing any penalties for non-compliance. There is also an envisioned mechanism of compliance orders being issued to companies if they do not comply with the diligence obligations. There is also a mechanism that would allow individual stakeholders to file civil claims if they find that companies are not living up to the due diligence obligations under this proposal. Again, we'll see exactly what is adopted in the end. The timeline is somewhat similar to the timeline for the forced labor proposal. So at present, and also bearing in mind that the EU has the elections for the European Parliament coming up in 2024, if this goes according to plan, proposals might be adopted by 2024, but really with the transition periods that are envisioned, they will probably not enter into force until at the earliest 2025, maybe even 2026. And with that, I will hand over to Chris to speak to the UK.
Thank you very much, Sarah, and good morning, good afternoon, and good evening from London, everyone. So we turn to the UK portion of today's session, which I have to admit, after the US and the EU sections, it does feel a little bit like the UK is starting to lag behind, but do bear with me, there may be some change on the horizon. So in general, the UK's statutory requirements relating to forced labour and supply chain transparency are pretty fragmented and light touch. So the key provision for today's purposes is Section 54 of the Modern Slavery Act, and this was introduced in 2015, and it's got a few key things you need to know about it. First, it applies to commercial organisations with a turnover of £36 million or more per year, which supply goods or services and carry on a business in the UK. So even part of a business in the UK, you don't need to be established or domiciled in the UK. As long as you carry on some business in the UK, you're caught. What it actually then catches you to do is maybe a little bit less concerning, although still important. So the second thing it requires is that any such organization prepares an annual slavery and human trafficking statement. And the statement is set out in really broad terms. So you either need to set out the steps your organization has taken during the year to ensure that slavery and human trafficking aren't taking place in any of your supply chains or otherwise in your business, or you have the option of simply stating that the organization has taken no such steps at all and bearing the reputational consequences of that. Key thing is you need to have the statement. The important thing here is just how much discretion is actually left to individual organizations. So Section 54 also does include a list of some information which may be included in the statement, including information about due diligence processes, about risk assessment procedures, about policies, training, etc. But all of this is wholly discretionary. It's up to you whether you want to include it or not at this point. There is a little bit more guidance on what is actually involved in that side of things, but again, the guidance is wholly discretionary in terms of what you comply with. So the third thing is that the statement must be approved by the board and signed by a director if you're a corporation, and if you're a partnership, there are some separate rules for that as well, but the idea is it needs to be signed off at quite a senior level. And finally, the statement has to be published on your website with a prominent link from the homepage. So if your organization doesn't have a website, you have to make the statement available on request. Now, the focus here is on transparency and self-regulation rather than coercive measures, as we were seeing in the US. There are no civil or criminal penalties for failing to prepare or publish a statement. The Home Secretary does have a power to compel organizations to comply via an injunction, but this procedure has never been used and there's no suggestion that it will be anytime soon. So the legal consequences of non-compliance are fairly constrained, although there is still a significant reputational risk component. Now, there have been a few studies on the effectiveness of Section 54. In 2022, the Financial Reporting Council sampled 100 LSE-listed companies, found that roughly 1 in 10 businesses weren't providing a modern slavery statement at all. For those that did, links from websites were often out of date or very difficult to find, and fewer than half of the companies were considered to provide a clear or comprehensive statement of modern slavery concerns in their supply chains. So this has, not surprisingly, led to some calls for reform. There was a government consultation on this and quite a lot of momentum building up to the Queen's speech in May 2022, when they announced they were going to introduce a new modern slavery bill to update the Act. The bill hasn't actually been introduced yet and hasn't been published yet, so we can only speculate on it, but based on what the government has announced and has published in other forums, the bill will likely make the following changes. So first, it'll likely mandate the areas to be covered in slavery and human trafficking statements. And the most likely thing is that the areas that were previously discretionary will now be required to be included in the statements. Second, requiring the statements, the statements will not just need to be published on a website, but also on a central, searchable government database. That's already been up and in place since 2021, but participation is currently still voluntary. And the third thing, and very important from a compliance perspective, is that you're likely to introduce civil penalties for non-compliance as well. So there'll be an increase in the detail that's required of your human trafficking statements, and there's also a turn to a more enforcement-operated approach with reputational consequences as well. So the next development that I'm going to talk about, just parking Section 54 for a moment, is the World Uyghur Congress case. So Section 54 isn't the end of the story for the UK. The recent case before the High Court of the World Uyghur Congress highlights other UK-based enforcement risks relating to forced labour and supply chains, as well as evidentiary issues associated with supply chain risk assessment in general. So it's quite an interesting case. It concerns an application for judicial review by the World Uyghur Congress, which is an NGO seeking to promote the collective interests of the Uyghur people. And it sought to confront the presence of cotton produced in Xinjiang in UK supply chains. So rather than seeking to challenge companies that had included their cotton in their supply chains directly, they sought to challenge the lack of action taken by UK enforcement bodies, including HMRC, the UK Border Force, and the National Crime Agency. And in particular, the World Uyghur Congress claimed that the enforcement agencies had not applied the law correctly when exercising their discretion. So first, in not investigating potential breaches of the Foreign Prison Made Goods Act 1897. So you might have 90 years for Section 307 in the US, Jess, but we have 130 odd years for the Foreign Prison Made Goods Act. But second, also the decision not to launch investigations under Part 7 of the Proceeds of Crime Act, which is the UK's principal money laundering regulation. So the Foreign Prison Made Goods Act provides UK authorities with the power to block the import of goods made in foreign prisons. And the Act places a burden of proof that the goods have been made in foreign prisons directly onto the enforcement officer. Now, the interesting thing here is this is a total reversal, a completely opposite approach of what's being taken in the US. The burden of proof sits with the enforcement authorities rather than there being a presumption to the opposite extent. Interestingly, the Parliamentary Foreign Affairs Committee in the UK has actually called on the government to impose an import ban on all cotton products from Xinjiang, operating on kind of a similar basis, but there doesn't seem to have been any appetite in the government to actually pick this up as of yet. As for the Proceeds of Crime Act, it sets out money laundering offences relating to the use of criminal property, which is property that constitutes a benefit from a person's criminal conduct, where the alleged offender knows or suspects this. So in this case, it was alleged that the cotton goods originating in Xinjiang and entering UK supply chains could be considered criminal property for the purposes of the Modern Slavery Act and for the International Criminal Court Act. So ultimately, the court held that the enforcement agencies had not misdirected themselves, and so they didn't need to go out and enforce in these particular cases. But there are a few elements of the case I'd just like to draw out. So first, the court was very reluctant to interfere with the exercise of enforcement discretion by any of these bodies to begin with. It's not a common thing, and they were quite worried that it would just mean that there would be lots and lots of legal challenges constantly second-guessing enforcement authorities' decisions to enforce or not to enforce any particular issue. Second, even though the enforcement authorities hadn't misdirected themselves on this occasion, it was open to them to investigate claims of forced labour in supply chains under the Modern Slavery Act or the Proceeds of Crime Act or the Foreign Prison Made Goods Act. So just because it didn't actually happen in this case doesn't mean that the enforcement authorities can't go after where they have sufficient evidence. Speaking of evidence, there was, this really highlighted quite a few issues with establishing the sufficient level of evidence to prove that a crime had been committed, but also in a way that ties into problems with supplying evidence in supply chains. So it wasn't enough to produce evidence that it was sort of very likely that goods coming from Xinjiang might be the proceeds of forced labor. You have to establish that specific consignments traced all the way through the supply chain had themselves been the products of forced labor. So that's quite a difficult evidentiary threshold to meet. There were also additional problems relating specifically to the money laundering offences. So in the context of long and complex supply chains, it's going to be particularly difficult to prove knowledge or suspicion of an arrangement relating to criminal property. So you're going to, every sort of extra step of the chain, you're going to get further and further away. And there's also a defense under the Proceeds of Crime Act relating to the purchase of property for adequate consideration. So the more tiers a supply chain has where fair market value has been exchanged for a good, the more distant the goods will be from being considered the proceeds of money laundering. So the case also highlights the increasingly sophisticated scrutiny which NGOs are applying to global supply chains and the use of strategic litigation to draw attention to the issue of forced labor in the courts and in the press. Very, very briefly, just to close out the UK section, it's worth noting that some Xinjiang provincial officials have been targeted under the UK's global human rights sanctions regime, but these are just focused on financial sanctions at this point. There's no hint that they're moving into the trade sanctions space as of yet. And for public procurement, even if they haven't been moving as much on commercial organizations, they are increasingly looking to bring forced labor considerations into public procurement supply chains. So the amendments to the Modern Slavery Bill are also looking to include public bodies, not just commercial organizations within its scope. And the UK Procurement Bill, which is currently before Parliament, also includes forced labor concerns as grounds for excluding suppliers from procurement opportunities. So overall, the UK is a bit behind the others, but there is still movement in relation to forced labor in supply chains. There's likely to be more in future, although progress has been a little bit slow.
All right, thanks, Chris. Thanks, everybody. One initial question from the audience that I'll put out there with respect to scope and risk is, what are the high risk products that we see? And I think it may be different from jurisdiction to jurisdiction. Chris, I mean, you focused primarily on textiles, cotton, I think. Jess, I think you've had a little bit broader. So maybe each of you could comment on which products you think might be initially targeted or the highest risk targets for enforcement.
Yeah, I mean, there's a lot of things relating to primary goods and, cotton, tobacco, foodstuffs, things that rely broadly on low-wage labor supplies throughout the world. So cotton is a really big one. Textiles, coming out of Xinjiang, there are also increasingly sophisticated sets of products as well. So there's a lot of input into motor vehicles, for instance, that looks like it's coming out of Xinjiang at the moment. So it's difficult to narrow down, and it feels like it's constantly evolving as well. So you need to keep a bit of an eye on these things.
Yeah, Jess, maybe you can talk about that evolution a little in the US, because we've certainly seen a change in focus over the last 9 months.
Sure. So at first, the task force identified cotton, tomatoes, and polysilica-based products. And they said that those were the emphasis areas. And it seems like CBP devoted specific resources to researching those supply chains. And if you look at the guidance for importers from 2022, there's even specific ways you need to disprove forced labor for those products that are unique to those supply chains. And so certainly US Customs is very aware of and tracking those, but then we've also seen a lot of talk about aluminum and auto parts lately as well. And so that seems to be something that's catching the eye of the US Congress. And like I said, it's broad, but those are certainly the focus areas.
All right. Jess, I had a question from you from the registration questions, which I think is important. We've seen a lot of clients performing what are typically called supply chain audits. And I think it'll be helpful if you speak a little bit about the adequacy of those sorts of audits to meeting the CBP guidelines that you mentioned during your initial presentation.
Mm-hmm. So these sort of third-party audits are encouraged, and they're listed by, as like potential evidence that you can use in overcoming the presumption for UFLPA. And they're, probably good practice for your company, but I don't think they're sufficient, right? So usually there's a difference between an audit and an investigation. The ones that I've seen are generally looking at, do you have a due diligence system in place? And then maybe they're checking off the ILO indicators. And seeing if you have any high risk indicators, which is very important work, but that is very different than disproving through supply chain documents that this particular good did not, was not produced with any forced labor down to the raw materials. And so I think that, the more detailed you can be and the more like documentation that you can have supporting it, that would really, back up more of a investigation. And note, there's a burden you're overcoming. This isn't just due diligence in the US. You're having to disprove the presumption.
Sarah, just picking up on that string a little, we have the CBP guidance, which is pretty express, pretty detailed. Do we have any guidance whatsoever at this point from the EU on what they might be requiring? We understand supply chain mapping, but what does that look like, and how does it compare to the CBP guidelines, do you think?
No, I mean, I would say standard fashion, when it comes to diligence principles in the EU, they're quite broad and quite vague as to how they're set out in the law. And just looking at, for example, other types of diligence that has been quite active as of late, if we look at economic sanctions, conflict minerals, and so on, the laws just set out broad principles and then recognize that each company is in a unique situation in that sense. So it's really for the company to shape exactly what diligence is reasonable to it, which of course there are pros and cons with that approach, because it really doesn't give companies much to go on in terms of what is sufficient diligence. And that's in the EU, that's a very common question surrounding these types of diligence obligations, and which I would expect would be very relevant in this context as well. Even though these two proposals that I just mentioned, they do try to set clearer standards for the forced labor proposal, for example. There is in the law even the obligation of the authorities to issue more guidelines to give companies more of a sense of exactly what they should be looking for and what documentation that they would need. But based on previous experience and the practice that we have in place here, I wouldn't expect it to be any more detailed than what we already have, and just mainly focusing on international principles and so on.
Okay. Chris, coming back to you and I think your initial observation that the UK could be regarded as maybe being a little behind the curve here. I'm curious in terms of the tight trading relationship between the EU and the UK, if the EU obligations will sort of, from a practical perspective, become mandatory in the UK as well over time in order to facilitate trade. What do you think about that?
Yeah, I mean, I think there are a couple of dimensions to that question. So first of all, I think that businesses that are trading with the EU are going to have to face up to these obligations, because they will be within EU supply chains, and EU suppliers will be within their supply chains, and so there's going to have to be some kind of coherence to the overall approach taken there, and the EU is likely to be, given the EU is currently out in front of the UK on this, it's likely to set whatever those standards are. Secondly, not necessarily in relation to forced labor in particular, but because of the operation of the Windsor framework, which till a couple of weeks ago was known as the Northern Ireland Protocol, there are some specific EU obligations that apply directly in Northern Ireland, which do have due diligence implications. So for instance, the conflict minerals regulation that Sarah was just mentioning, and also the batteries regulation. So that's not necessarily going to include all new EU legislation. It's only stuff that's already listed or something that amends what's already listed in the Windsor framework. But there will be stuff that applies directly in the UK, and that's also going to have an impact.
All right. There's a question from the audience that I'll just answer very quickly before putting some more questions to the panel. The question is, in the United States, is there any distinction under the UFLPA with respect to private versus public companies compliance? And the answer is no. It applies equally to everyone. Jess, there's another question from the audience I want to put to you and also add a little to. So the question relates to whether the sort of evidence that's required for products that have been detained to show that they don't have a supply chain that runs through the Xinjiang region. So could you speak a little bit about that, and maybe at the same time talk about situations where people in the supply chain are resistant to actually providing that kind of evidence to submit to CBP.
Sure. So we know from the statistics that many of the goods that have been detained have in fact been released, but we also know that CBP hasn't reported to Congress any exceptions, so presumably those goods are proving that they're out of scope, that they don't have a nexus to Xinjiang or to the entities listed. And the evidence is going to look very similar. You still have to do a detailed trace of your supply chain with documents showing the origin of the goods, and so those are going to be, again, your production records, your payment records, your accounting, your inventory, movement, bills of lading, import, export, all of that sort of documents. And again, we trace it specifically to the exact goods that are being imported. And then what was your second question, David? Oh, about some resistance that we've seen to this?
Yeah, I mean, one of the questions was, how do you deal with that? How do you try to address that and get around it?
Yeah, it's difficult because a lot of times suppliers don't want to tell you who they're sourcing from for competitive reasons, right? And thankfully in the US, we have a good system in our other trade cases where we can protect business proprietary information. And so we've had some success doing that with non-disclosure agreements where the suppliers will release to the attorneys and to the US authorities the information in the supply chain, but then we guarantee that we will not share it with their competitors or with the other members of the supply chain. So that's one way around it. As I mentioned, there's also some concerns that Chinese law might be interfering here and might not allow the Chinese nationals to provide this level of, personal information about workers and things like that. And then also, it's just a lot of work to do it. And so there's some resistance to that and companies saying, maybe I should just move my supply chain. And, so if you're a Chinese producer and, or you have a factory in China and you're willing to get all of these things in place, you could really have a competitive advantage.
All right. So Sarah, back to you for a minute. You mentioned one of the big differences about the EU's regime is that it's not just forced labor that's at issue. It includes environmental issues, for example. So, thinking about harmonized compliance programs, does it make sense? How practical is it to think about a compliance program for forced labor that also includes environmental concerns and other aspects of the regime that you described?
Yeah, it's an interesting question, especially for us that are maybe looking at this more from a trade perspective and that have more experience looking at supply chains in that sense and dealing with the customs authorities and so on. And it is an ongoing debate, especially if we're looking at the EU proposal for the directive for due diligence. It's an ongoing debate because actually the EU Council has issued an opinion saying that really this directive should focus more on environmental principles. Not sure if that is because that is perhaps considered less controversial and more straightforward in that sense when it comes to the diligence that would be required. So there are clearly diverging views as to where these initiatives on the EU side, where they should land. So environmental issues, certainly, judging by the initial indications, would be something that you clearly would have to take into account on the EU side as well. So, I mean, the trend that we see on our side is to not just look at the forced labor due diligence documentation that you can show in that sense, but also looking at it more from a broader ESG perspective and looking at environmental principles. So would be most likely, I mean, it's still up in the air on the EU side exactly where it's going to land, but that's a pretty good estimate that the environmental part is going to play a big role.
Okay. Sarah, back to you for a second. A lot of interest in UFLPA here. Question relates to how far down are you required to drill in terms of your supply chain? It says, if you vetted down 3 or 4 levels, are you in good shape? Where do you have to go in terms of your query?
For UFLPA, you have to go all the way down to the dirt. So all the way down to the raw materials.
Yeah, and I would just add, I mean, that's a big challenge that we've seen with various of our clients where oftentimes the tier one supplier is willing to cooperate and is quite helpful. But once you get further upstream from that tier one supplier, you start to run into a lot of resistance and a lot of difficulty. And, you know, frankly, in many cases, it's simply impossible to go behind that tier one supplier, at least in our experience to this point. We wonder if that's going to change over time as people decide for that reason to change their suppliers. You know, over time, it may be that the incentive for people to cooperate further upstream in the supply chain to stay in business and to continue to service existing clients, that pressure becomes so great that people change their position. But to this point, that's a huge challenge. All right. One question I wanted to put to all three of you before we run out of time is, you know, one of the things we mentioned in arranging this was how might somebody go about putting together a compliance program that simultaneously meets the requirements of all three jurisdictions and maybe other jurisdictions too, besides the ones we're talking about. So thoughts on that? What might that look like? And is it realistic to think that you could accomplish that?
I can start from the EU side and say that that would be very difficult today, also because we don't know exactly what the EU framework is going to look like. I mean, we've already discussed that the diligence principles as such that you would need to implement as part of a compliance program would probably be based on pretty broad principles. So it's really up to each company to figure out what works best for them. One question would be, and I guess I would pass on to Jess to speak to that. Would you be in a good position by essentially following whatever is expected on the US side today, and then expect that that will be in your favor when it comes to the EU frameworks being put into place? Yes, it's a pretty drastic measure for a company though, so it really depends on where you are as a company, if that is something that really makes sense to you. I mean, again, I come back to diligence principles under economic sanctions, for example. The US has very much been in the lead for that and imposing very strict or very, very broad expectations on companies in terms of the diligence that they're expected to do there. For quite some time, that seemed quite unrealistic on the EU side, but now with the Russia developments, maybe that makes sense. So it really depends on developments that we can't predict today, if that is something that a company would want to do. But with that, Jess, happy to hear your views on the US side, what makes sense from your perspective.
Yeah, I think that because the US measures are so strict that most likely, if you're able to get your goods into the US, then you're probably meeting the standards for the other jurisdictions, with the exception, of course, that the US is only focused on forced labor. You're not proving any environmental standards or anything. And then also, you know, there's no required reporting in the US. You have your third-party audits and your traces and your maps, but there's not, you know, you don't have to publish a report like what we're seeing from the UK. I think you're muted, Chris.
There we go. On the UK side, you know, as I said, these are much lighter touch obligations and everything else. To the extent that there is guidance on this relating to the Modern Slavery Act provisions, it's quite similar to the UK, to the EU's approach of really leaving it to businesses to decide how they want to structure it by very broad reference to the UN guiding principles and the OECD framework on multinational enterprises. So it may be that that becomes more detailed if and when the Modern Slavery Bill comes in. And it's also probably worth mentioning that the 2021 Labour Trade Policy, which I'm sure is due an update in any case, also did commit to legislating for specific due diligence requirements to cover breaches of international human rights agreements and ILO standards on forced labour. So there is probably going to be an election towards the end of next year, and things may change after that, but it's still a bit up in the air at the moment.
I mean, my takeaway from the discussion is that the US requirements, as typical, are over the top, right? They're extremely burdensome. The due diligence, the document tracing, the accounting information that CBP has outlined in the guidelines establishes a very high standard. But if you're able to meet that standard or come close to it, I think it's highly likely that once the EU's requirements are established, that US compliance would provide the basis for supplying the information that will be required, probably with respect to the UK. The question ultimately, I think, is whether people can actually meet the CBP requirements, whether it's for US purposes or for purposes of compliance in other countries vicariously. So I think that's it for us. I want to thank the panel. Nice job. And I wanted to thank all the attendees for signing up and participating today. We appreciate it. And if you have questions, other points you want to follow up on, please feel free to contact us. And finally, thank you, Lucy, for making everything run smoothly today. We appreciate it.